Um, so I am here today. Welcome, everyone. For those of you who are joining for the first time, my name is Lindsay Ramschusel. I am an attorney at CMS based in London, and I am joined today by one of my bosses, Guy Pendell, who is a partner here at CMS and is honestly the lawyer who knows the most about AI of any lawyer that I know. And he also happens to be an expert arbitration lawyer. You're on the ICC National Committee for the UK, is that right?
Yep.
Yep. He's also sits as arbitrator and access counsel. He is one of the big names in arbitration. He's ranked in chambers, I'm pretty sure.
Yep.
Yeah, so he's kind of a big deal. So I'm really excited to have him here with me today. He is also the co-founder of an award-winning AI arbitration startup that just won a GAR award. So hopefully we can talk about that a bit more as well. But Guy's here today to talk about AI and the changing landscape of arbitration. And as with our normal format, we're going to go, Guy's going to talk for about 20-ish minutes about the topic, and then he and I will have a conversation that hopefully the rest of you will also feel free to join in on, and we can go from there.
Thank you, Lindsay. And hi, everybody. Very nice to see you. I'm just wondering, should we sit back a bit?
Yeah.
It's going to work. I'll lean in. I'm just going to try and give you 20 minutes by way of a bit of a background. And I'm going to approach this to try to think about this in the way I think the title of the session was put, which is the changing landscape of arbitration. So there's a lot of discussion about AI at the moment, and we're getting to a point where actually I think people are starting to feel a bit more comfortable with it. We're hearing repeating messages about the types of AI issues that are arising. But I think what's really interesting is where this might take us. So I was going to structure what I talk about and cover this probably in four main areas. So the first is really just talk about the sort of where AI is at the moment and frankly, why are we talking about it now? Then I want to talk about actually what tools now exist. So what's already around and perhaps what's about to come or what's just landing and how we're dealing with that. And then to bring this more into the focus of arbitration, I want to talk a little bit more about really sort of how we think AI is going to start being used in the practice of arbitration and raise some of the issues that are likely to arise for practitioners, for arbitrators, even for institutions in terms of how they grapple with those sorts of things. And then because we're talking about AI and we're future facing, let's actually then have a bit of a chat about what the sort of future scenarios might be. How will AI change that landscape? So let me start by actually a disclosure. Now, Lindsay knows this already, but in preparing the notes for this session, I decided that it would be quite a good idea to get some help from someone. On this occasion, whilst I very often turn to Lindsay for help on these sorts of things, I decided maybe not to on this time. So I asked Copilot instead. So I got some input from Copilot. I'm not going to tell you which bits of what I might say are or aren't from Copilot. You might be able to work it out. But as will become apparent, everything I'm about to say, of course, I have to take direct personal responsibility for, and that's something that I'll come on to later in the context of how we as professionals use AI. So, quick one for those who aren't familiar with it. So, what is AI? AI is actually a term that is encompassing a huge range of technology that now exists. The reason we're all talking about it right now is because of something called generative AI, which everybody, well, almost everybody, I think, is aware, really hit everyone's consciousness in late 2022 with the launch of ChatGPT 3.5 that just exploded into everyone's consciousness. But of course, AI was already around before then, and AI really talks about an activity that's conducted by a computer that gives an impression of human intelligence. And it's important that I say it gives an impression of human intelligence, because the two terms, artificial and intelligent, they're really misunderstood, and in particular the word intelligence is misunderstood in terms of any of the technology that we're seeing at the moment. There is no actual intelligence behind it. There is no thinking. It is computer processing, but just very advanced computer processing based on different types of algorithm models. So what we're seeing is there are some sectors in particular where AI has been really taking over. Now, you're all familiar with this because I suspect you use tools every day or devices every day that are influenced by AI. So the obvious one being if you use any form of social media, the feed that you get into your social media is not what happens to randomly appear, but it is based on algorithms that are using a form of AI to actually work out what particular feed you might want on your AI, on your social media. That's LinkedIn, whether that's Facebook or any of these things. What's also happening is we're starting to see this being developed more and more in particular areas. So the healthcare sector is embracing AI in quite significant areas when it comes to things like diagnostics. They're quite far ahead, actually, of the legal sector. Certain areas of financial services have already been transformed. And even as we're hearing, the entertainment world is being disrupted at the moment. The strikes that were going on in the US recently was all around concerns around individuals who were not having, worried about whether or not they were going to be, their images were going to be produced as in AI and was going to do the magic job. So we can already see what's going on there. Generative AI, and the reason why we're all talking about this, is one that is all around how advanced the technology is in terms of using natural language now. And I'm going to work on the basis that everyone on this call has used some form of ChatGPT already. So you have a basic understanding of that. But the reason it matters for us as lawyers is if you think about it, what do we do as lawyers? You're an arbitration lawyer or something else. We take large amounts of data that is significantly in the form of natural language. We read that, we interpret it, we make sense of it, we summarize it, and we reformulate that into something that then can be presented in the legal world. So that's really what we're talking about and why we're having this call now. And what that means is lawyers are now having to grapple with technology that rather than purely assist them as a simple tool is going to introduce new ways in which we might actually have to start working. And that, I think, is what's generating the interest. So, what are the sorts of tools that we should be expecting to see? Well, here at CMS, we've already been trialing a great deal of the technology. So we've used things like Pi and ChatGPT. Those are two examples of really quite simplistic versions of generative AI, which are basically chatbots. But they're just chatbots that operate at an advanced level, and they can give you quite remarkable responses that really make you feel like you are having a conversation with someone intelligent. You can then move on to other types of technology, and I put in this things like Claude, CoCounsel, and Harvey. And these are systems that are being developed to operate really more at an enterprise level, where specifically they're built within what's sometimes called as a walled garden, which creates a confidential space where you can use the technology, and you're being powered by the large language model to then produce an analytic capability. And this is where I think we'll start to see the technology have an impact on how we work as lawyers, because we can upload documents into these environments. So you might put clients' underlying papers, you might put memorials, written submissions into these environments and actually use it for forms of analytics. And then we've got things like Copilot, or we're on Zoom. There's an AI feature on Zoom now where you can have a transcript produced and it will give you summary information. So this is where, again, you can imagine that as we're turning more and more to virtual hearings, but even if you have a non-virtual physical hearing, you can use this technology to actually produce a live transcript, but not just that, but then actually you can do something with that live transcript within the generative AI environment that you're in. And then even in areas where we might be dealing with discovery or disclosure, there's a new tool that's just come out in Relativity called Relativity Air, which introduces the large language model capabilities in the way in which you might analyze underlying documents as well. So we've got all these tools that are available. Now, there's another one that I'm going to mention here, which I will disclose that this came from my discussion with Copilot last night, which was something called deepfake. And it was described as a tool that can create realistic synthetic images, audio and video of people such as witnesses, experts and parties based on existing data and manipulation. And perhaps we'll come back to whether or not that's a tool that we will use in arbitration, or whether that's a tool we need to be alive to other people using in arbitration.
Hint, not ethical.
Which is a good segue into the next section, which is, okay, so how are lawyers actually going to start really working with this technology? So if you're a lawyer just starting out and you're working in arbitration and you are planning to continue working in arbitration for the next 10 to 20 years, possibly even the next 5 years, I would say that you need to have on your wish list quite high up, I need to really start making sure I understand how this AI technology works, because it's coming. So if you're a lawyer in this world, the first thing I would recommend is actually trying to get a handle on really what this is all about. There's a huge amount of information out there. Lindsay circulated in advance of this some draft guidelines that have been presented by the Silicon Valley Arbitration Center. And I thought it was good to circulate those because it will give you a feel for the sorts of issues that some arbitration practitioners are thinking about. But there's much more information. And one of the things that we recommend to our lawyers here within CMS is, I think, a free access piece of information that the Financial Times put out, which I think they call their AI primer. It's a very good summary and explanation, not just of AI, but how it actually works, what some of the underlying technology is behind it. So I'd recommend that. What I'd also suggest is that as part of that exercise is try to understand how this works, but also what it's good at and what it's perhaps not so good at. Because one of the consequences of giving the impression of intelligence is that you can sometimes be fooled into thinking that it is actually intelligent. And that's where that's not the case. So those who are starting to use the technology are starting to see what you can do. So for example, very simplistically, I might ask a generative AI tool to produce a first draft of a document. The one thing I'm never going to do is ask it to produce a final draft of a document. Indeed, I might decide that actually I want some drafting suggestions, but actually more importantly, what I want is information about actually the topics and the material that I might want to include within a draft, and then I'll take responsibility for producing that draft. As a lawyer, obviously we are dealing in, especially in the world of international arbitration, with a confidential process. So unsurprisingly, lawyers who are thinking about using AI do, of course, need to think about, if I use this technology, am I going to be doing so in a way where there is proper data security around its use? And then there's another issue that I'm going to raise, which is bias, because for anyone who's read much about AI at the moment, you will find the word bias is referenced quite often. And bias here, I actually think is giving AI a bad name because of some concerns that have been raised previously about the way in which data is played back based on what might be a biased data set. Now, I think we're moving away from this, but I'm just going to raise another perspective about bias, which is for those people who are starting to use AI on a more regular basis and are using it in a brainstorming capacity or trying to bring an extra thought, a different thought process into the room. I think what you will find quite quickly is it could actually illuminate the biases that you have rather than the biases that it might have. Because what it will show you is you may have a fixed view in your mind about something, but then when you start engaging with the technology, it will bring a different perspective, perhaps, to the way you thought it was going. And I think that's a really positive thing. Okay, so how am I going to think about AI as in a particular role? So let me think about it as an arbitrator. So I'm sitting as an arbitrator. First question, and maybe we'll come back to this as a discussion. Do I want to know whether parties or counsel in the arbitration are using AI? And I'm just going to pose that as a question right now, and maybe we'll come back to it. But what are the sorts of things that I, as an arbitrator, might be alive to? Well, since I mentioned it earlier, might I be alive to the possibility that some form of AI has been used to create some sort of deep fake image, or possibly it's been used to generate, I don't know, witness evidence, expert evidence? Can I rely on that? Now, just posing that question, is that materially any different to how an arbitrator weighs up evidence at the moment? do they need to just think about the possibility that there may be more at stake here or not? We'll pause there, we'll come back to that later. What about as counsel? Should I have any concerns as counsel about either a party or a tribunal using AI? So for me as counsel, which is what I most commonly do, will I be concerned about the other side using AI? Actually, no, I won't. But the reason I won't be concerned about the other side using AI is because it's my intention that when I'm in an arbitration going forward, that I will be more advanced and better equipped to use the AI than anyone else in the room. So I hope that won't be an issue, and I'll be alive to have the way in which AI could be used. But I will be alive to this. I can see that there is a role for AI in supporting a tribunal. And let me give you some examples of that. Drafting a procedural order. There is no reason in principle why you can't use AI to help with that process. There are already tests being done to do this. What about drafting a procedural history in an award? What do people think about that? Let me take this a bit further. Summary of evidence. Is that okay? So for an arbitrator to ask generative AI to produce a summary of evidence? What about reasoning? For the AI to be used to help set out some potential reasoning for a particular view. And let me take this to the final stage. What about if an arbitrator is actually using generative AI to give a view on a potential outcome? And that's where I think it gets interesting. Because I would be, maybe concerned is the right word to use, about the possibility that an arbitrator might ask a generative AI system for its views on a particular outcome in a case where the arbitrator has been appointed. Now, why would I be concerned about that? Because if the arbitrator has said, it's okay, because the final decision is going to be mine. Well, here's my view on that. Once an arbitrator has, for example, consulted with some generative AI and that's given a view, the arbitrator can't unknow that. And the interesting question is, would that influence the thinking of the arbitrator? Now, I think that gives us all pause for thought, but let me just turn that round a bit. What about if exactly the same question was asked by an arbitrator of a tribunal secretary? And what do we think about that? So I think it raises some interesting questions around what an arbitrator might choose to do in terms of using the technology and what disclosures arbitrators might. I did mention I'd cover institutions as well. So just very briefly, what might an institution do with generative AI? First of all, I think it could significantly speed up some of the processes that institutions operate. So things like checking the identity of parties. What about arbitrator selection? Is AI going to be a good tool for arbitrator selection going forward? I think it possibly is. What about dealing with challenges to arbitrators? That could be something where there may be a role for it as well. I've mentioned case administration. I think that's absolutely something that is going to be looked at, and possibly even award review. What about if an arbitrator submits a draft award? Can an institution use generative AI to actually check the award? Possibly check it against a pre-existing case, a checklist that perhaps the institution has trained the AI to use in order to check it. That could speed things up. So I'm not necessarily against it. And then here's a really controversial one. What about an institution, perhaps that's been in existence for several decades and therefore is sitting on a large body of evidence? Oh, sorry, not a large body of evidence, a large body of data from confidential arbitrations, including possibly hundreds, if not thousands, of pre-existing awards. Is it okay for that institution to start using that data, either to inform future decision-making that the institution uses, or possibly taking it to its natural conclusion to monetize the value of that data or the significance of that data in some way? And how does an institution deal with confidentiality issues around that? So that's some ethical and regulatory sort of issues that I might raise as well. There's one that I've already alluded to, and that is the role of the lawyer in all of this. And I do think it's important to raise this, which is, as far as I'm concerned at the moment, all of this technology is nothing more than a tool for a lawyer to use. And here's why: because as an advocate, as a solicitor, as a lawyer appearing before a tribunal, I will have ethical responsibilities. The buck stops with me. I might use AI to help me, but I'm not going to use AI to help me and then use it as an excuse when it goes wrong, because I have that responsibility. So that's just a point I wanted to raise. Now, the future, this is maybe where we get into a bit more of a discussion. So I'm just going to throw a few things out there now. And in fact, I'm just going to start with this maybe, and then we can have a discussion. Do we think that we might be moving to a future where actually clients will choose to have their cases decided using some form of AI? And I already have a view on this because I have asked clients about this previously. In fact, I asked clients about this probably more than 10 years ago, and I got some answers there. So I've got a lot more to say, but I'm conscious that we're already half an hour in, so maybe I'll save that for a discussion.
Oh, that is, yeah, I think that'll be a really interesting discussion. So we've moved on to the discussion portion. Just as a reminder, I'm sure you all saw this when you logged in. This meeting is being recorded, so I know our previous discussions were under Chatham House rules. This one, theoretically, we can say it's Chatham House, but there is a recording that's going to be out there. So just want to make sure that everyone's aware of that, because, and I did ask you about that.
Yeah, no, I'm fine.
Yeah.
To be perfectly honest, I don't think there's anything I'm going to say that I would be concerned about being repeated anyway. So we don't even need to treat it under Chatham House.
Okay. But anyway, if you would like to ask a question, just raise your hand and we'll call on you. Or if you want to put a question in the chat, we can also read it. But basically what's going to happen, for those of you who haven't joined before, is Guy and I are going to have a discussion, but hopefully it is not just Guy and I who are having this discussion. And normally I'm not in the same room with my guest speaker. Normally they're on a different continent, but this time, because we are in the same building, we're in the same room. And so don't take that as an exclusion of you from the conversation. We want you to join in the conversation. The more you guys are talking, the better. But until then, while you're getting your juices flowing, thinking about potential questions, I have a couple questions that I want to follow up with based on what Guy said and then also some of the things I've said. But one of the things I think that I always think about or hear people talk about is AI is going to render X job obsolete, right? And obviously, like you said, I don't think we're at the point, and I don't think it will be at the point for a while where all lawyers in arbitration are going to be rendered obsolete. I do, however, think that, right now we work on sort of a pyramid structure with a lot of people, and especially at the entry level, doing a lot of work that AI can do. So for people who are looking to get into the arbitration world and gain experience so they can become the person reviewing the work that AI does, how do they do that in the world of AI?
Okay, so let me take two aspects of that, or maybe three. So the first thing is, if it were the case that in the future there will be no more arbitrations than we currently have, then I do think it is right that there will probably be slightly less work to do for lawyers as part of that process. But the reason I think there is perhaps a lot of unfair focus on that is that actually, if you look at almost every technology that we've had in the past, what it has tended to do is increase productivity, and that by definition tends to increase accessibility of legal services, for example. So a lot of people are looking at this in a very positive way to say this could actually make the provision of high quality legal services far more accessible to more people. And it could even be seen in an even more ambitious way as possibly kickstarting not just the equivalent of the Industrial Revolution, but actually a new technical revolution that is going to see an explosion of more work. So that's the starting point. I think the next thing to say is I haven't found a single report that is going to say sort of lawyers are going to be out of business per se. What I have seen is reports that recognize that some of the work that lawyers currently do will now be done by technology, but it doesn't necessarily mean that there won't be a role for lawyers. And we've done lots of experiments and tests with the available generative AI tools at the moment. And actually, just to share it with you all, most of the overwhelming experience of people who participated in those tests is one of being somewhat reassured, because I think it's given them confidence that this technology is great, but there is absolutely still a role for lawyers. So does that answer enough of your question?
That answers some of my question. I think I guess what I was getting at is things like document review, things like checking the references in a brief or creating an index, things that we often have, creating a bundle.
Yes.
Things that we often have junior attorneys do so they can gain the experience and learn how things work. And then at some point, they get to the point where they're the mid-level associate reviewing that work.
Mm-hmm.
In the world of AI, how can you get the experience to get to that mid-level?
Yeah.
That, I guess that's, if you have any thoughts about that, that's the question.
So I think you will still need someone to do that exercise. You might be asking the AI to actually undertake some of the drafting of that. But I come back to the point, which is we have professional and ethical duties as lawyers. So, I am going to expect that I'll have a team that will still be helping me with that exercise. I might still ultimately take personal responsibility for the delivery of that, but I'm going to be still expecting lawyers to be helping with that. So you might not, and let me put it in this way, and I encourage all of you to think about this on your next working day, which is break down within your day how much work is done where you are using your brain in the most challenging way you do. How much of your day is spent doing what actually is quite administrative work?
That would be about 80% of my day.
And if you can take away that administrative responsibility and therefore think how much you can then start really using your brain for what it was trained for, you can start to see the real benefits.
Yeah, I get that.
But there is an interesting point that you raise here, and I think a lot of us have recognised this, which is, okay, but how do you learn in the first place? Because a lot of us learned by doing these tasks originally, which is why I think you still want a lawyer in the loop, or a human in the loop, as sometimes it's referred to. And I absolutely see that there is value there. I also think that actually what we may also find is we will start using this technology for training purposes as well, because we are now in a scenario where you could potentially hone your skills as an advocate by popping on some VR goggles, going into the metaverse, and actually conducting a cross-examination or an arbitration against generative AI avatars.
So basically, instead of me trying to convince someone to be my fake witness when I'm practicing my crosses, I can just use...
Actually conduct a cross-examination in the metaverse.
Does that exist?
Well, the metaverse exists.
Well, no, but I mean a program with a fake witness.
I'm not aware that it does at the moment. So there's a business opportunity.
All right, yeah, everyone joining, business opportunity. Get your developers on it. Your developer friends who made the smart decision and decide to become programmers instead of lawyers. You can work with them on the next legal tech. I'm pretty sure U.S. law firms would pay a lot. Fake juries too. Imagine if you had a generative AI jury.
Well, and I mean, you can take this further, and we're already seeing some examples of this at the moment, which is because through prompting generative AI, you can actually ask generative AI to behave like something else. So as this technology becomes more sophisticated, if you had, hypothetically, a retired judge who becomes an arbitrator, and you really wanted to understand how that retired judge might think, you could drop every published judgment that judge has produced into AI, and either in just a written format, or if you wanted to simulate how you think that judge might behave in an arbitration, you could then start to simulate this type of situation.
Wow. I'm just thinking through that could be pretty interesting. Are there any questions before I move on to my next question? Anyone? Okay. So my next question is, you talked about a walled garden,
yes,
right? The example of, so what are people who are just getting started in the AI, looking into AI and work, what kinds of things do they need to know about with walled garden software? How's that work, and what can they do to make sure that whatever they're doing is, follows their ethical rules about keeping things confidential, keeping arbitrations confidential, that kind of thing?
Yes. Okay, so I have the benefit of being a partner at CMS, and we have, as Lindsay knows, a significant infosec team whose job it is to look at new technology and satisfy themselves that it meets certain standards around confidentiality and data security. Now, this does raise an interesting point, because what if you're a sole practitioner? What if you're an arbitrator and you're practicing on your own? How are you going to grapple with this? And I do think there's an issue there, because that does raise an interesting point as to whether you might be at a disadvantage because just having access to some of the software may be more difficult as an individual. And I recognise that, and I think some of the institutions are starting to see that that could be something that they need to address. It may well be that in the same way as you can either have group subscriptions to things and individual subscriptions to things, what we may find is as some of the enterprise software, as some of the enterprise tools come out, an organisation like CMS may take it as a corporate and have it throughout its organisation, but it may well be available for individuals in subscription. At that point, you're going to have to at least make sure you are clear as to what the minimum infosec security requirements are. And maybe as lawyers, we need to make sure that we understand that a bit better. And in fairness, I talk about walled gardens, and I very much understand the principle that the whole point is that the data you use within that tool never goes anywhere else. Now, I can understand that conceptually, but to what standards do I need to go to actually satisfy myself at a technological level that that's the case? And that raises some interesting points, I agree.
Yeah, and I think it raises questions about, especially for arbitrators using something like that. You know, as you said, a lot of them work alone, or they work, or even a barrister working with chambers, you know, like the chambers have a subscription, but does that mean that your matters would be walled off from other matters that other people using? Yeah. Or would you have, you know, can you create walled gardens within your overall software walled garden? Interesting things to think about. But my next question is about disclosure. Okay. So you talked about this a bit.
Yep.
But like, obviously, think about it. Like, there's different levels of AI that we're all using already. Like, I don't know, I'm not going to make you raise your hands, but who uses Google Translate? That's not generative AI, but it's still AI, or machine translation, right?
Well, actually, Google Translate is a form of generative AI.
Yeah, Google Translate is a form of generative AI. Now, we are not allowed to put client documents into that, but I can tell you that I've definitely used it when I'm researching a case and I come across the French ISDS case.
Yep.
You know, it's public information. I'll pop it into Google Translate. Do I have to disclose that? Probably not, because I've been doing it since before anyone even thought this was an issue.
Yeah.
But at what level does it get to the point where you should consider disclosing that you used AI? Or consider, like, what level of generative AI do you need to disclose, or should you disclose?
Well, so right now there is no requirement, at least in any of the institutions or rules that I'm working within, that would require me to disclose any form of AI.
Yes. The Silicon Valley rules, I should say, have two different proposals on when you have to.
And there's a debate about that.
And there's a debate.
And by the way, these are guidelines.
Yes.
So it's actually, the suggestion there is that an arbitral tribunal might think about adopting those rules if they become rules, which would then apply in the arbitration. I think there's going to be an ongoing discussion around whether that's necessary or not. I don't know where that's going to end up. And actually, I haven't really tested these views with many other practitioners. I think what's quite interesting is my sense is that for counsel to use AI, if they're ultimately still taking personal responsibility for the submissions they make, why do you need a disclosure? Now, if there is a concern, for example, that let's say photographs are being submitted in evidence and there is a belief that there might be a deep fake, that raises an interesting question as to whether the tribunal might say, I want some form of certification, or I want to test the validity of these documents. But how is that any different to a forgery being submitted in an arbitration or a case presently? You still have to address that in the same forensic way. I do think it raises an interesting question if an arbitrator or a tribunal is intending to use the technology. But I can see a hand is up.
Yeah, Agnieszka.
I just wanted to, can you hear me? Because I have my headset now.
Okay.
I wanted to just note that I was working on a matter where we were using to a certain extent, automated translation, but that was a walled off. It was an internal one, and all of this securities where in confidentiality was in place. But it was agreed between the parties, because there were a lot of different documents in different languages, that that automated translation can be used, but had to be indicated, and then any issues with the quality of the translation could be raised, and those documents would have been sent to a proper translator to kind of verify, or sworn translator. And there was a way of saving costs and also time in preparation of the matter. So, but that was agreed between the parties, because they knew that they both will face the same issue. And this was not something that was mandated to be done. But I think without this adopting rules for the future that are followed by everyone, it will be quite difficult to weed situations where someone is taking advantage or undue advantage.
Well, and I think we'll also, I think we'll also see similar agreements with AI run disclosure.
Well, I want to come back to AI disclosure. Just on Agnieszka's point, it's a really good example, because actually, how different is that to the way in which we might currently run translation? So the difference here is, right now, if you weren't using the technology, you might produce what we would roughly call an office translation of a document. But it's quite common in procedural orders for it to say, if either party challenges the authenticity of the translation, they can do so, and then you can get a certified translation of the document. So the example Agnieszka is giving is, instead of just having an office translation, you're just having a AI translation, but still with the right to challenge that, and then for the opportunity to go and get a certified translation at that point. So the interesting thing is, it's not materially different to the process that we've already adopted. But let's come on to disclosure, because this is where I think we get into some interesting territory.
Because now already parties are agreeing search terms. And for decades, especially, I mean, coming from my US litigation background, when people have millions of documents, they were using certain forms of AI to find documents and pull them and like narrow your document pool before they got to human review. And that was something that often was agreed with the other side in procedural orders, so that it was all transparent and everybody knew about it. But when we bring better AI into the process, what do? Do we need to disclose it? Do we need to agree on these things? Obviously, there's a huge cost saving to using AI for disclosure. So what are your thoughts on that?
Okay, so this is where I'm going to have to talk about litigation a bit as well as arbitration, because one of the main differences, particularly in jurisdictions where we have disclosure or discovery, is that there is already a lot more technology being used in litigation where there's a discovery or disclosure obligation. Typically in arbitration, there may well be systems operating behind the scenes, but certainly across Europe, we see very much a disclosure or discovery process following something like the IBA rules. Now, the IBA rules are really good, but actually what they don't address is something that's become much more sophisticated in litigation, which is, how do you actually go and harvest the documents in the first place, and what is the data set you're using? So I can see this is a good area where we might see arbitration evolving into a more sophisticated process, where actually you might easily automate a request to produce in accordance with the IBA rules. So bizarrely, that actual process becomes much easier once the tribunal have ruled on what requests will be made. But what is going to become much more relevant is, what is the underlying data set that request to produce is being applied against. And that's where I think we might see the IBA rules starting to reverse into a process where the parties are satisfied that there is a valid data set that is being used in the first place. And the reason I say that is because I can genuinely see that you'll get to a point where you don't undertake a physical exercise of responding to the request to produce. Each party will agree that, for example, they will adopt a common e-disclosure platform. And because the e-disclosure platform is capable of operating at a large language, sort of high language model level, you just drop the request in and it responds, and counsel just then review the documents for privilege, and then the documents go over. So that's an example of where things may change.
Do we know if anyone's working on that type of a product now, or?
Well, that's what, my understanding is that's what relativity air is capable of doing. So I think products of that nature are either here or just around the corner.
So document disclosure is my least favorite part of arbitration. So if there's a way for it not to, for me not to have to do hardly anything, that would make me very happy. Any other thoughts or questions before we move on to talking about arbitrators disclosing their use of AI? Because I do think this is one of the interesting, one of the most interesting things that that we've talked about. So there's obviously, just throwing out there to start us off, there's obviously the concept of, and my Latin is terrible, but iuria novi arbitra or something like that. Basically, the arbitrator knows the law, right? So in some jurisdictions, the arbitrator is entitled and expected to either know the law or have the ability to research the law and to cite to cases or statutes that are not cited by the parties. So if that's the case, could that research include asking, you know, Westlaw's new AI generation tool to help it find relevant cases, and should they have to disclose that?
So I'm going to, I don't know this for a fact, but I'm going to hazard a guess that in arbitrations in the past, arbitrators have used Google to identify what might be relevant case law.
I would not object to that. I don't know, Amelia, I guess you probably can't say what you do in either arbitration.
Now, I wouldn't necessarily ask anyone to disclose what they do, but I think that happens already. And the question is, it's a good question. What is the boundary of the assumption that an arbitrator knows the law? Does that mean that an arbitrator is expected to have everything in their head when they start the arbitration and they don't do anything else? Or are they entitled to actually think about that as part of the process and conduct themselves as a professional, which involves not necessarily just making things up or thinking that you can remember a case, but actually being able to go to a reference point and identifying that. And I think this is not a material move beyond. So I think, frankly, if they're using a knowledge platform that happens to have AI capabilities, I don't think there would need to be any disclosure of that.
Or let's say, moving on to another, so right now, parties often negotiate in their procedural order if they're concerned about undue delegation from an arbitrator to the tribunal secretary. I mean, which, again, depending on your jurisdiction now, sometimes, I think, isn't it the Netherlands that basically just said the secretary can write the whole thing as long as the arbitrator's okay with it? So depends on your jurisdiction and your seat. But is there much difference between saying, well, the tribunal secretary will write the procedural history and the summary of the arguments, but will have nothing to do with writing the deliberative aspects, or saying we are going to have this generative AI tool summarize the pleadings and the procedural history? You know, does that need to be, I mean, I'm assuming it would need to be disclosed, but is there a difference between having a tribunal secretary or generative AI do that?
So it's a good question, and I think this is where, as you recognize, there are different practices in different jurisdictions. Yeah. But if I take the experience I have, which is typically arbitrations conducted predominantly with a common law background, what I would see is often, as you say, disclosures around the role of the tribunal secretary, and in particular what they can do and what they can't do. And I can see a practice evolving which would be similar in how a tribunal might disclose the use of AI. So, and I gave that example before.
Yeah.
Would anyone object to an arbitrator using AI, for example, to produce procedural history that goes into an award? Maybe they would, maybe they wouldn't. I suspect most people would feel more comfortable with that. But then you get into the incremental steps that get closer to it. And I do think that that is a space where there probably is a case to say, I think there maybe should be some disclosure. But let me approach it in a slightly different way as well. And I posed this question before. If someone was able to offer a version of arbitration, and it was understood that at the outset what parties are buying is AI-assisted arbitration, where there is a human being at the end of that process that is effectively putting their name on an award, but they may use AI to assist that process. If the parties are going to that platform, specifically for that function, then in effect, they know what they're getting, and that's what they're signing up to. And this is where there's an interesting debate about where the market forces are going to take us. And none of us know what the answer to that question is. But that may be where we end up. There's an important legal point here, which is I am not yet aware of a country that has a lex arbitrary that would allow an entirely autonomous process to produce an award. You can have an autonomous process to produce a decision, but it won't be an arbitrary award.
So you're saying that even if AI created the decision, you would need a human appointed as an arbitrator to actually review it, sign it, and turn it into a legally enforceable award?
Because a computer cannot be an arbitrator. Now, I have not conducted an exhaustive search of arbitration laws around the world, and I would be interested if anyone has looked at a particular law somewhere to say, well, actually, as a matter of construction, I think that would be okay in this jurisdiction. But the other possibility is that what we might see is actually a jurisdiction that is looking to gain some advantage over technology, introducing this capability into their law, possibly with some guardrails.
All right, so Amelia.
Thank you very much, Lindsay. Thank you, Guy, for the discussion so far. I'm just wondering, just a different view, which is not necessarily a national law that says you can do that, but a question really, why would an arbitrator want to put their signature and their name to an award they have not written? Is there an ethical dimension to that? And, you know,
I think if it's a rubber stamp, I agree with you. Why would an arbitrator want to do that? But actually, can we rule out the possibility that we will see a new breed of arbitrators that are AI assisted, and that they're not necessarily saying, I will always follow everything that the AI does, but what they're saying is, I'm going to use AI, for example, to conduct an assessment of the relative weight of the evidence in the case. Or I'm going to use AI to assist me in weighing up the competing legal arguments that are being put forward by the parties. And the question is, how far through that process do you go? If actually what the arbitrator is doing is simply saying to the AI, draft an award based on this information, and then I'll sign it, I agree with you. If we get to that point, I think we're actually more likely to be having the conversation, do you need the human at all?
Okay, so just a quick comeback, which is that by the time we get to that point, institutional rules and national laws would be amended to permit that. And as long as parties are aware, that's what you're signing up for, which would have an impact on the cost of your arbitration, by the way, then it should be okay. Again, you get that push between party autonomy and, well, justice, and what type of justice are we looking for? So that might be hopefully in a couple of decades when some of us would have completely retired.
We can all guess on that. I think the one thing I would add to that is that this gets us actually into the broader question of the extent to which we're going to have regulation of AI. Because if you look at the EU AI Act, I think what you would say is if we got to that point, we're probably in an environment where the EU AI Act would apply to that process. And so at some point in the future, we will probably have more well-developed guardrails than are currently being considered, and that would then kick in at that point. And I suspect we will end up with some degree of regulation there, mainly because if you're using an underlying AI system, you probably want to have some degree of confidence that you're using one that is using a quality underlying data set, one that isn't going to introduce bias, one that doesn't introduce a sort of natural inclination always to find in favor of someone called Lindsay as opposed to someone called Guy.
I mean, I would put that in the coding in my AI system. So no, that's what I'm saying. You'd need transparency on the back door of the AI, right? But then you would also hopefully need fairly sophisticated people to review that and also test it.
Well, you would, or what you will have is you will have regulation, so that if you wanted to offer AI arbitration, you may do it, but have to comply with a minimum regulatory standard in relation to that, or simply you would be operating illegally. Now, you could end up in an interesting question around forum shopping, because does that make a particular jurisdiction that has lower standards a more attractive place to set yourself up for an AI international arbitration platform? I don't know. Market forces might say people will choose not to use that because they will want a degree of comfort that these systems are operating within, as I say, guardrails.
Yeah, so my brother-in-law is a computer person, a tech person, and he and I had a big fight last summer. It was a discussion. It was a very heated discussion about whether, we will not need judges anymore or arbitrators anymore. I kept saying, well, I'm too concerned about bias, and what about the human element? And there's certain things that, I can't trust a computer to read facial expressions and demeanor and witness testimony the same way I can trust the person. And then he kept saying, no, actually, they're better.
Yes.
And so anyway, we ended up agreeing to disagree, but he probably was right on a lot of stuff, and I was just stubborn. Agnieszka, you have another hand.
I actually wanted to make a quick comment on what Guy just said about the forum shopping, where the arbitrations might have been done by use of AI entirely or to a certain extent, would be yet another issue in award enforcement, because one thing it would be to get an award somewhere, but then a question of how can you enforce it in a jurisdiction that possibly does not recognize such a process. So that would, just be yet another hurdle and thing to consider.
Yeah, you might have to amend the New York Convention as well.
Or, public policy exception under the New York Convention, right? Like, depending on the AI, they could say, well, this type of decision-making was contrary to the public policy of our country, so we're not going to enforce it.
So I'm just going to give you one different perspective on this as well. That we are all assuming that arbitral awards in the future will need to be enforced. Now, that might not necessarily be an accurate assumption to make, because if your arbitration process is one that is embedded in an entirely digital contract or a smart contract, it may well be that the decision of the arbitrator, including an AI arbitrator, would immediately lead to self-execution of the contract in a particular way that would mean you would never have to enforce the award anyway.
That sounds both interesting and terrifying.
Maybe.
Can you tell us a little bit about Pink DQ? Because obviously I know from the website it says AI assisted arbitration, but given everything we've talked about, how have you designed your platform? It's like, what is AI exactly doing? What are humans doing? As much as you can talk about it, because again, it's award-winning, guys. So, but it's not trying to put us out of work.
No, so at the moment, there is AI in almost every technology that is being used. And I do not want to suggest that Pink DR is currently at a process of using AI in the decision-making process, because it's not. At the moment, what we focused on is building an efficient platform that allows you to get from the beginning to end of an arbitration process very quickly, but all of the key decision-making is talking about right now. However, we have a development path for Pink DR where we have identified somewhere in the region of about 8 to 10 particular points in the arbitral process where we have identified the potential to introduce an AI element in that process. And I'm not going to say now how far we will go with the adoption of that technology. In theory, we could introduce the potential for use of AI in every single stage in that process and allow the parties to opt in or opt out of that as they prefer. I think what we will likely do early on is to leave the main arbitration process as it is, but introduce an early, optional AI early neutral evaluation process. So that the parties, and again, probably on an opt-in basis, but if the parties wanted, either mutually or individually, to have an early AI evaluation, they can choose to do that in order to inform their decision making, for example, as to the level at which they might choose to settle.
Can you tell us the difference between evaluative and generative AI? Is there a difference? I saw something that mentioned a difference between them.
Okay, generative AI right now will give you an evaluative view on something, but it's questionable whether it's genuinely evaluative or not. What is a sort of an interesting question is, does any of it actually amount to evaluative at the moment? I'm interested to hear what someone would have to say about that, because I don't think any of it is strictly evaluative in the way we mean it, because actually what we're talking about when we say evaluative is thinking. That does not necessarily mean that when we use evaluative in the context of MAIENE, it's actually evaluative in the current standard of maybe something.
Well, I think we're a little bit over time, but is there any other questions that we have? Anyone else have anything they want to say? All right. Well, thank you so much for joining us, Guy. We really appreciate it.
Thank you for letting me use your device to join.
Yeah. Well, so obviously technology is not perfect, but yeah. Hopefully, I will put. You had mentioned something, and I'll put the link in the chat, and it'll come through in just a second. But the FT primer on AI.
Primer. Yes.
I will put that in the chat for the Zoom meeting, so that any of you interested in learning about what these. Do you need an FT subscription for it?
No, I think it's free access for everybody.
Okay, we'll put that in the chat. That explains some of the basics of AI that are helpful to understand, so that you can have a better understanding of everything that's happening. We really appreciate you joining us today. Amelia, I don't know if you have anything you want to add.
It's just to say a huge thank you. Thank you to Guy, and we hope you will come back and share some more on your work and all the development you guys are doing on this. So a huge thank you. Thank you to those who have attended. We will, I think, Lindsay, do we have another session next month?
That was something I'd asked you about, because the email that you sent had said April was the end. Or
yes. So this should be our last reading group for now. For this academic year, those of you who are students or who were students, which is all of us at some point, you remember that term and semesters come to an end at some point, and students basically start prepping for exams, and exams would soon start. So we will take a break, and we should be back soon. But our newsletters, you'd keep getting the newsletters, and that would let you know when our next webinar would be. I must say a huge thank you to Lindsay, who's been faithfully moderating this, leading on this our reading group, and who hopefully would agree to continue doing it.
Yep. Happy to do it. And if any of our participants have particular topics that they would like, you can email me at my CMS email or send me a LinkedIn message. Please add me on LinkedIn. Send me a LinkedIn message, and we'll see if that's something that we can work into next academic year's calendar. Yeah. We do have a couple of decisions that we're tracking that hopefully once they come out, we can have a group discussing those decisions. There's some interesting stuff about treaty interpretation and anyway, that we'll talk about. But hopefully, yeah, if there's something you want to talk about, you want to read and discuss as a group, please let me know, and we'll make it happen.
I think I like that. That reduces our own workload.
Yeah,
and don't
exactly.
forget that, of course, you have the sectors.
You find topics.
Just let us know what you need, and we will try to deliver that. So thank you very much, everybody, and do enjoy the rest of your evening.
Thanks. Bye.